Mandated family violence response. Family violence in Georgia is defined primarily in three statutes: OCGA 19-13-1, the Family Violence Act, OCGA 17-4-20, and OCGA 17-4-20.1. These statutes define family violence crimes by crime type and relationship of disputants. OCGA 17-4-20 gives criteria for warrantless arrest and defines agency responsibility to provide training for officers with regard to family violence and elder abuse. A qualifying family violence crime may result in an officer making an arrest with or without warrant when the officer is able to establish probable cause. Aggressive arrest policy has proven to be the most effective law enforcement intervention in family violence cases. OCGA 17-4-20.1 contains requirements for officers when responding to a reported incident of family violence. Georgia family violence law provides a number of chargeable misdemeanor crimes, which may help to prevent further incidents. When arrest is not possible, written documentation of the incident and victim services referral by the officer is still required. This block of instruction is designed to provide officers with a general overview of what defines an incident as family violence and the officer's obligations under Georgia law when responding to incidents of family violence. Specific protocols should be addressed within department policy. The Family Violence Act defines incidents of family violence by crime type and relationship of the disputants. Family violence is primarily a crime of power and control. The victim/offender relationship impacts the investigation, prosecution, and safety of the victim during the process. The investigating officer has a critical role in assessing the offender's access to the victim. Most family violence incidents will be charged as misdemeanors. The likelihood that the offender will be out of jail on bond prior to the trial is very high. Proper assessment of the relationship aids prosecutors and judges to make bond decisions. The investigating officer should never minimize the effectiveness of intervention at the misdemeanor level. Misdemeanor crimes charged under the Family Violence Act may carry enhanced penalties. OCGA 17-4-20. This code section allows officers to make arrest with or without warrant when probable cause exists to believe a crime of family violence has occurred. The crime is charged as a crime against the state. Georgia is not a mandate arrest state. However, most agencies have pro-arrest policies when probable cause can be determined. Aggressive investigation and arrest on family violence incidents is the most effective law enforcement intervention. In cases where there is sufficient probable cause for arrest, the officer still has the obligation to document the incident and to advise the victim of other services available. Creating a safe scene is the officer's first responsibility. Once the disputants are separated, the officer can begin to interview and assess the statements against the physical evidence. The officer may have to continue to point uncooperative or untruthful subjects back to what the evidence is showing. All involved parties and any other witnesses, including children, should be interviewed. The responding officer should never leave the scene until ensuring the welfare of everyone in the residence. The victim's statement may change once they have time to come down from the immediate fear or anger of the incident. It is important for the responding officer to get an accurate and complete statement at the time of the incident. It is a good strategy to use the evidence on the scene to help clarify any contradictory or unclear points in the victim testimony. Asking questions about the first time the victim can remember any violence in the relationship can help to establish a pattern or history of abuse. The officer is building a case on the evidence of the current or most recent event. Prior incidents of family violence between the defendant and the same victim may be used at trial to establish prior history of violence in the relationship. These previous incidents may be useful in prosecution as well as helping the victim to assess future risk. The officer should also ask about the offender's history of violence in previous relationships. The victim is often a good source for this information. These prior abusive behaviors may also be used at trial if substantiated. The professional response by the first officer to have contact with the victim has been shown to influence the cooperation of the victim throughout the criminal justice process. It is helpful for the officer to reassure the victim that the abuse is unacceptable and that the victim is not responsible for the behavior of the abuser. The first responding officer should document all excited utterance statements by all parties. Observation of the demeanor and physical condition of the person making the statement should be documented in the officer's report. The physical and mental condition of the person making the statement may help to validate the statement later. The officer should attempt to video or audio record any statements. Written statements are valuable tools for prosecutors at trial. When completing the victim interview, the officer should ask specific questions about injuries and other physical evidence. This is the best time to get the victim to commit to an accurate statement. If the victim has injuries, the officer may want to have them sign a medical release form in the event that medical treatment is sought. The victim should be given written contact information for both governmental and non-governmental services. The officer should also encourage the victim to utilize local services available to them. The elements. The elements of a good report and case file include interviews of all parties with knowledge of the incident. This includes all witnesses and any children. Once again, any documentation of prior history, whether reported to law enforcement or not, is crucial. Physical evidence. Victim and witness testimony may change prior to trial. Physical evidence is the only infallible piece of evidence. Failure to properly obtain and document physical evidence may result in no evidence at trial. Photographs are an excellent way to document injuries, property destruction, physical appearance, and the presence of children on scene. Injuries will heal. Sometimes the photograph may be the only evidence of injury. In keeping with department policy, recordings of 911 calls should be requested in all cases resulting in arrest. When victims or witnesses become unavailable for cross-examination at trial, much of the testimonial evidence may be lost. As a general rule, calls for emergency assistance can still be used at a trial even when the caller is not available. 911 calls have tremendous value when played in court. Typically, the caller is in an excited state, and additionally, background noises from the ongoing incident may be heard. Recording of calls to 911 by victims or witnesses may often be omitted even when the victim recants testimony. The local district attorney is best suited to advise on the admissibility of 911 calls in their jurisdiction. Every family violence incident will not result in arrest. In these cases, the officer should provide the victim with as much information on local victim services as possible. There's clear evidence that victims who utilize services beyond law enforcement have a greater chance of surviving the abusive relationship. Provide officers with a list of available services in your community. The professional, consistent response of law enforcement to family violence incidents is a critical first step towards survival for many victims. Aggressive investigation and arrest coupled with concise documentation aids the criminal justice system in providing for the safety of victims and the accountability of offenders. First responding officers have the greatest opportunity to create positive change for the victim of abuse and the abuser. Adherence to state statutory requirements and department policy with regard to family violence response is an effective deterrent to further violence.